didn't have the authority to stop me, and therefore the questioning was illegal and the arrest was illegal. And then I go into the fruit of the forbidden tree doctrine. All evidence gained from an illegal contact must be suppressed as fruit of the forbidden tree doctrine and may not be introduced at trial. This is how the Fourth Amendment works. If they stop you and they don't have reasonable, articulable suspicion that a crime has been, is being, or is about to be committed, and they subject you to interrogation or arrest and detention, any evidence that they may have found in your car or on your person or in your house or wherever has to be suppressed. They cannot use it against you. It's called the fruit of the forbidden tree. They can't break the law in the name of enforcing it. They are bound by the Constitution. Yes, Kevin?
When I had this situation with my daughter's ticket in Fruita, that particular, what you just said there, breaking the law in order to
Enforce it?
they've ruled on that. The Colorado Supreme Court has ruled on that exact statement you just made, saying even though that may have been a illegal act that was committed, it still didn't justify that traffic code was being broken, or speeding, or the illegal turn, or whatever.
I need to see that case.
I'll get it for you.
I absolutely need that.
Yeah, I researched some case law on that. I got access to some case law website, and I found that.
That might come in handy here real soon. Thank you, Kevin. I definitely thank you for bringing that to my attention.
Can they break the law?
It was the town of, the original case was the town of so-and-so, and it was a jurisdictional thing. Excuse me, I'm sorry, I didn't mean to interrupt.
That's all right.
But they were writing tickets in the city and county of Denver, and they were their own entity, separate city, and they were writing the tickets into their courtroom, into their jurisdiction.
Okay, so.
And the court said, hey, we're troubled by this, but for the sake of protecting the system.
Okay, now every case is unique in that it has a particular fact circumstances. And the reason the fact circumstances are in the record is because evidence was tendered into the court and the evidence tells a story. Okay, you can never actually get back down to the facts. You can give evidence and paint a picture, and the jury has to be the finder of fact. Really, the best storyteller is the one that wins. Here's a set of facts. What story can you make up about it? Okay? That's the way the legal system works. It's an adversarial system. The first thing that they do teach in law school to these lawyers is that, folks, this is an adversarial system. So it's all about the fight. And so, in this case, I raised this issue that I made a motion to suppress all of the evidence, including who I was, because the initial stop was illegal. All right? That's what, and so last Wednesday, and several people were here, thank you for coming, and thanks for coming to that hearing too. I appreciated the support. The question on the table, there was only one question on the table, and was the stop reasonable? Yes, no. So we spent 2 hours putting on evidence. The burden of proof was on them. Remember I talked about burden of proof if you're challenging a constitutional statute is unconstitutional? Burden of proof is on you, the person challenging. Well, in this case, the burden of proof is on the state. All stops that are, thank you. All stops are presumed to be unreasonable. You're going to love this. All contact, police-citizen encounter, is presumed to be unreasonable. The burden is on the state to prove that it is reasonable. Okay? This is huge. They carry the burden of proof. So I'm not in there trying to prove that it was unreasonable. They're in there trying to prove that it was. So this was the argument. And there's another couple of cases. Oh, now there's a Supreme Court. This is 367 United States Supreme Court, page 643. This is the U.S. Reporter. This is another volume of the Supreme Court, 81 Supreme Court, page 1684. This is a 1961 case. This is another volume of law. This is called the Lawyer's Edition. So these are 3 different volumes of law, all citing the exact same case. And that's how you read law. That's how you read court decisions. Wong, Son versus United States, that's a Supreme Court decision. Mapp versus Ohio, that's a Supreme Court decision. And People versus Lewis, that's a Colorado Supreme Court. But all of these cases support the idea that evidence gained from an illegal contact must be suppressed as fruit of the forbidden treaty. So those authorities are called persuasive, mandatory authority. Excuse me, I'm going to eliminate the word persuasive. This is not authority at all. This is a law dictionary. This is not authority at all. This is a law dictionary. You know what? It has no authority in the courtroom. You quote Black's Law Dictionary in the courtroom, they'll laugh at you, unless you're doing it to clarify the meaning of a word. This has no authority in a court except to persuade. So the Supreme Court cases, these are mandatory. They have no choice but to follow these decisions and how they apply the law in the certain fact circumstances. All right, so here's my final argument. The traffic stop was unreasonable and therefore a violation of Colorado Constitution, Article 2, Section 7. Colorado Constitution has an equivalent to the federal Constitution's Fourth Amendment. And so I cited both. And the reason I'm citing them both is because I wanted to make a federal case out of it. So I could get into the federal case, so I could get into the federal circuit. And that adds a little extra weight to the mandatory obligation that the court has to follow. So I also cited Colorado Constitution because this is really a state issue. This is the state of Colorado enforcing the revenue laws. So that's why I went with both. And then I came down here, and Trooper Hilling, this is the name of the officer, his conduct in initiating the traffic stop and arresting the defendant constitutes an act of official oppression in violation of 188403(1)A and official misconduct in violation of 188404. They're creatures of law, they're bound by the law, they're subject to the law. He also committed perjury of oath because he has an oath of office to support the Constitution. And in this case, ignorance of the law is no excuse. So these here are misdemeanors. So now the cop, in an attempt to enforce the law, committed misdemeanors because he arrested me. What was the reason that he arrested me? He didn't know who I was. Because it was his position that he had committed an investigatory stop and I had an obligation to comply. So the question came down to that the judge had to decide was whether or not that constituted reasonable suspicion to warrant pulling me over in the first place. And then, of course, there's my closing. I challenged the statute itself. The statute itself is unconstitutionally vague in that it does not provide citizens, police officers, and the courts alike with either objective or sufficient guidelines to prevent arbitrary enforcement. The statute says if your vision through any glass equipment is normal and unobstructed. If it's not normal and unobstructed, then you've committed a Class A traffic infraction. So I'm raising the question, what does that mean? What is normal? And what does unobstructed mean? These are terms that are not defined in law. Due process, the Fifth Amendment of the federal Constitution, and there's also a Colorado Constitution equivalent, requires that the laws be plain and understandable and concise. And if they're not constitutional. So just because a law violates, one part of the Constitution doesn't mean that it doesn't violate another. A law could violate several parts of the Constitution. But if we don't know the constitutional parts that it might violate, like due process, we don't know how to raise the issue. So, just to hedge my bet, and I did this basically, this was Linda's idea, to challenge the constitutionality of the statute itself, to give these guys a way out and basically throw Trooper Hilling under the bus, which is essentially what the judge did because she granted my motion.
Yay!
So,
On what grounds did you say? Everything?
unreasonable.
It
It was an unreasonable stop. So the judge agreed with me, it was an unreasonable stop, and as a result, all the evidence obtained because of the unreasonable stop was thrown out, case dismissed. At
You
least,
said you never won.
well, that was until last week.
But David, if you wouldn't have known all of that, then they would have just went ahead and the judge would have agreed with the cop, right?
Absolutely. They would have nailed my butt.
So the police officer would have been able to break the law that they're supposed to be under,
Yes.
and the judge broke
And
the
they
law
do
too.
it all the time.
And they would do it.
And they do.
Because you didn't
And-
know that. So if
and-
that happened to me and I didn't know any of that, I
Right,
would be in
that's why
jail.
you're taking this class. That's why you're taking this class. See, again, if we want to fight a war, we got to start with some foundational principles. We need to have this, we got to stay on the moral high ground. And when we start fighting them with their own law and their own principles, because we've got the Constitution and Declaration on our side, they don't. Yes, sir.
You're gonna, I'm sorry.
You made the comment that you knew this was taking place, and you were basically looking for this fight. Did you know this officer?
No.
You just knew that this was taking place, I guess, in Montrose County?
Well, I know people that live up and down this stretch of highway, and there's a lot of complaints about arbitrary stops on this stretch of highway. And so, based upon that information, and I wasn't there trolling for cops, okay, don't misunderstand me. But I had decided that the next time I got pulled over, that I was going to see where it went. And when he told me that newspaper was obstructing the windshield, I thought, okay, here we go, this is the one. This is the one. And so it was an experiment in Liberty. It was an experiment on my part. I was pretty sure, I was sure enough to go ahead and get arrested and sit in jail for 23 hours, and I never got a phone call until I finally gave up my
Is
fingerprint.
this still on your record, or was that
No,
taken?
everything is gone.
Are you gonna file charges against the judge, the jail, the cop?
I have to. You know, initially, I spent a couple days kicking the can down the road, and then I caught up with the can again a couple days later. Yeah, I have to. I have to. I don't want to, but it's an effective tool to, again, re-educate them that there is a supreme law of the land, and that they are creatures of law, and they're bound by the laws just like we are. So I am against this will be the first time I've gone on offense like this. I've avoided going on offense like this, and here I was practicing the principles of the gospel as I understood it, turn the other cheek, and, do good to those that would harmfully use you and all that stuff. And I tried all that on, and nothing changed. This country is different. We have the people being sovereign. We have a responsibility in this country to call our government back into account, and this is one way of doing it. So yeah, I'm going to, and I'm already working on exactly how that strategy is going to go. So what we'll do is, over the course of the next however many months we do this, I will actually show you what I'm doing as I go through it, show you how to write a complaint, show you what motions are, show you what affidavits are. I can show you how to use the rules. I can teach you what the rules are, teach you how to do legal research. The idea would be to put you in a position, and you know what? It gives you a lot of confidence to know the law and to know your rights. It gives you a lot of confidence to live again and not be so afraid of these people. They're going to do what they're going to do. Well, we got to do what we got to do. And education has to be at the root of this thing. So, humble ourselves and pray and seek our Father's face, turn from our wickedness, get educated, learn the principles of law, and use the law in a way that it was intended to be used to secure the inalienable rights endowed upon us by the Creator. And because the government has overstepped the boundaries of law and has become destructive to the end it was established for, we actually have a duty. Now, I don't really like the idea of picking up a gun when I can pick up a law book assuming we get on the other side of this, whatever's coming, there's going to be a real dire need for men and women to know the law so that we can begin to rebuild this thing after it collapses, should it come to that. Yes, sir?
David, a point on this. Are you going to ask for any restitution on this event? And I bring this up because I realize when I walk into that courtroom, they got a ton of people are being paid to be there, and I'm paying the bill.
Yes.
To work against me. I'm paying a lawyer, and the whole thing is so slanted to the system that it just pisses me off.
Yes, I completely agree.
No, and that's the other thing. I mean, the system is deadlines, and it takes a lot of time to research all this stuff.
Yes.
That you're busy working, being a slave for the system, and so yeah, it just compounds and compounds, and you're really almost forced to pay for an attorney.
Okay, well, here's...
It's very hard to be a pro se litigant.
Remember
even though I don't know what the statute is that says you should have every right to, and there's some groups over here, some of the defense attorneys seem to be promoting some more of that, but it's probably more for if we were all illegal immigrants, we'd probably have to do some more.
I've learned over time that it's not a justice system, although they like to promote it as that. It's a justice business from top to bottom.
Yes,
And it's run like any other business. If you've got the money, you got the time, you got the power behind you, that business works for you. But
The
it's
biggest
just a
wallets
private
win.
citizen.
Look at Mark Cuban for Dallas Mavericks. Just beat the Fed, and he.
Look what O.J. Simpson got away with.
Yeah.
Well,
Well, but that's what we're talking about here too, is where David was saying was the initial traffic stop. The statute themselves are vague and ambiguous, so they invite arbitrary enforcement by the officers. So if we understand that, we take it from there, knowing that it's all arbitrary and it's their paycheck. It's their payday. And so if we understand that from the beginning, then we can go, yeah, okay,
Anytime
this
you're
is
in
where
that
it
courtroom,
stops.
You're paying for all your adversaries. You're paying
Right.
your adversaries to attack you. And then you're paying your lawyer to protect you. The whole thing's just a business. There's no justice.
We have
It's
the best
actually worse
system
than
of
the
justice that money can buy.
it really is. You know what,
Yeah.
the district attorneys, the ones that actually are the prosecutors, they see it as a game. And the lawyers, they really see it as a game, and it's about their personal status and success and promotion and stature. And it's unfortunate that they come into it thinking in terms that this is a game.
They're taught that.
But it is, in their mind it's a game, and we're merely tools within that game that they're playing.
David, are you finished with the
Just about, I
motion?
just want to make one more thing, and then we'll just do the
Well, I
question.
want to say something about the motion to suppress, though.
Okay.
When the judge found that it was, in fact, an unreasonable stop, after we got up and we left the courtroom, David was on the telephone, and we were all in the courtroom. I made sure that I walked behind the officer as well as the district attorney. And the officer asked the district attorney if they were going to appeal the decision, because they have until the 30th to do that. And he said, "Are you going to appeal the decision?" And the prosecuting attorney said, "I don't think so." And then they hurried and shut the door behind them. But the reason would be is because it's vague and ambiguous, and it's attacking their moneymaker. It's going right after the moneymaker.
Now, I don't know, let me just finish up with this, and then we'll get into questions and answers. I just want to go back and make reference. Okay, and this is another little war story. And some of you know this, so forgive me for being redundant and telling the story again, and I'll just hit the highlights. A year ago, this month, a group of us went and we were going to go reopen a Forest Service road. And the reason that we were going to do that is because we knew the law was on our side. I had done the research, I understood jurisdiction, I understood where the limitations of the federal government are. I knew about this on this particular road. And so about 45 of us showed up, and our intention was to open the road. We went there for one reason. Now, someone called the Forest Service, and the district ranger met us there with his law enforcement.